Case No. CH 2022 BRS 000009, previously BL 2021 BRS 000036, in the High Court of Justice Business and Property Courts in Bristol before His Honour Judge Zaccaroli between Mr. Shucker claimant and Inspecs Ltd defendant. Law grounds. 3 laws that were not respected. Part A, the right to have a translator-Audi Ultram pattern. Part B, the right for a fair trial. Miscarriage of justice. 2 affidavits of the defendant contradicts each other. Part C, the maxima that a judge cannot sit on his own case. BPBW is bungle page before Wales. Zaccaroli is bundle page before Zaccaroli. Maxima. Nemo debet se iudex. In propria sua causa. Dimes v. Grand Junction Canal 1852, UK. A Human Rights Law Act 1988, you have the right to a fair and public hearing that is held within a reasonable time. Is heard by an independent and impartial decision-maker. Allows you representation and an interpreter where appropriate one. Skeleton arguments before His Honour Zaccaroli request for a permission to appeal. 1-206. Grounds for Part C. Maxima. Nemo debet se iudex. In propria sua causa. Dimes v. Grand Junction Canal 1852, UK. 1. The claimant translated all the documents of the Israeli judgments from Hebrew to English by a notary and apostille. The defendant translated documents from Hebrew to English through a private translator she paid, and the translator is not a company or citizen of UK and not supported via affidavit, only an oath. 2. His Honour Zaccaroli should ignore all the background noises to understand the main claim of the conflict between the claimant/appellant and the defendant before His Honour Wales. The claimant asked to void/not to accept as legal case 894917 Shucker v. Inspects of the Israeli Supreme Court Final Order January 2021. Because of the reason that 2 of the justices of the tribunal were partial and were sitting on their own case and having an interest. In Israel, the Supreme Court is the last resort. The head of the tribunal was Mrs. Hayat, the president of the Israeli Supreme Court, degree same as Lord. Cottonham of the well-known case Dimes vs. Grand Junction Canal 1852. The second in rank was Mr. Mazuz, a Supreme Court Justice, retired April 2021, has a degree also as ex-attorney. 3. Attached the appellant's notice. Appendix 1. Zaccaroli 28-35. 4. Attached His Honour Wales order date February 8, 22. Appendix 2. Zaccaroli 36-38. 5. Attached His Honour Wales refusing the request for appeal. Appendix 3. Zaccaroli 39-40. 6. Attached the skeleton argument before His Honour Wales hearing date February 8, 22. Appendix 4. Zaccaroli 41-63. 7. Attached the transcript approved via His Honour Wales. Appendix 5. Zaccaroli 64-122. 8. Attached final order case 894917 Tribunal of 3 January 2021, Israel Supreme Court. Last resort according to the convention. Appendix 6. BPBW 22. Zaccaroli 123-130. 9. Attached the protocol of case 894917 second and last hearing. Appendix 7. BPBW 73. Zaccaroli 131-143. 2-206. 10. Between Israel and UK there is a convention since 1971, the Reciprocal Enforcement of Foreign Judgments, Israel, Order 1971. According to the convention, UK courts should respect Israeli Supreme and District Court orders. If they are not legal, such as a judge was sitting on his own case, the UK courts should not respect it since it contradicts UK Human Rights Act 1988, is heard by an independent and impartial decision-maker. 11. A question. Is case 894917 is a claim in a matter of business Schucker versus Inspecs? An answer, yes. 12. A question. Has the lawsuit been filed in the English Court of Business? An answer, yes. 13. A question. Is the amount of money of the lawsuit suitable for the district court? An answer, yes. 14. A question. Is the physical distance of Inspecs 26 kilometers from Bristol District Court? An answer, yes. 15. If so, a technicality question is left. A question, on the assumption that it will be proven that the ruling 894917 of the Supreme Court contradicts Human Rights Act 1988, because judges had an interest. Does the District Court in Bristol has the authority to step into the shoes of 894917 of the Supreme Court, and hear the appeal? The answer is surely yes. 1. According to the Convention. 2. The Human Rights Act. 3. The Maxima Nemo Debet Se Iudex in Propria Sua Causa, Dimes v. Grand Junction Canal 1852, UK. An answer, yes. 16. First, we look the source was given before Honorable Wales, before the hearing. The skeleton argument page 11 bottom on the right paragraph 11.6.1 here is the quote. Before His Honor Zaccaroli it is Appendix 8. Zaccaroli 144 to 146. 1. On August 1, 2019 a hearing was held in the appeal in question, and its ending. While paying attention to the different claims for disqualification that the appellant raised before the justices of the tribunal, it was decided that the appellant needs to file a separate petition and a separate reasoning to each of the justices of the tribunal that the appellant wishes to disqualify them in order that each of the justices will give a decision as is required. 2. In accordance with the aforesaid, on August 12, 2019 the appellant filed a petition to instruct that I will be disqualified from presiding in the case. The appellant's main claim was that in the past I presided in another proceeding in his matter, P.C.A 143714 Schucker. 3. 206. Versus Inspects Limited, May 19, 2014, hereinafter, the previous proceeding. And because of my rulings in that proceeding I need to recuse myself from presiding in his matter now. The appellant also referred to what is said in his petition to disqualify Justice M. Mazuz, which was filed on October 21, 2018, and in it he claimed that he filed a tort lawsuit against the court administration that in it he raised, inter alia, claims against my rulings in previous proceeding, C.C., Magistrate Tel Aviv, March 18, 4062 Schucker v. The State of Israel, December 14, 2018. The appeal that the appellant filed against that proceeding is still pending at District Court in Tel Aviv Jaffa, C.A., District Tel Aviv, January 19, 4318, and according to the appellate existence of pending proceeding in which claims were raised against me also requires my disqualification from presiding in his matter. Eventually, the Justice Selection Committee it is inappropriate that I will preside in his matter, since as a result of my membership in the aforesaid committee, I may deliberate on the promotion of judges who deliberated on his affairs in various court instances. In order to complete the picture, it needs to be noted that the appellant also filed simultaneously to this petition to disqualify Justice M. Mazuz, who is a member in this tribunal. 3. The petition needs to be denied. The condition for disqualifying a judge from presiding in case is that there is a real concern of bias on the side of the tribunal, CA 4569-19 John Doe v. Jane Doe, paragraph 4, August 7, 2019, and it was already ruled that the same tribunal held a previous proceeding in the matter of a litigant does not raise in itself a cause for disqualification. In order to substantiate such a cause, the applicant is required to show that there is a real concern that the judge's opinion has been fixated because of the previous proceeding, C.A 2004-18. I do not believe the fact that I deliberate in the previous proceeding raised such a concern. The previous proceeding was a petition for permission to appeal, which was denied by a short decision that its reason was that the decision that was the subject of the petition for permission to appeal was a decision regarding procedures, which is given to the expanded discretion of the court instance that deliberated on that case. It is obvious that such a decision cannot lead to the conclusion according to which my opinion became fixated with respect to the matter of the appeal, or that under these circumstances there is a real concern of bias that justifies my disqualification from presiding in this matter. You need to add to this that the claims that the appellant raised in C.C. March 18, 4062 regarding my decision in the previous proceeding do not point to any true personal interest, as is required in Section 77A, A1, that I have in these proceeding or in their outcomes. End of quote. 4206. 17. Below are copies of the documents provided by the appellant BPBW 48-50. 5206. 18. Here is a summary of what has been in the documents, which were translated by a notary, and confirmed via an Israeli apostille, case 8949-17. Shucker vs. In specs, date August 21, 2019. The petition is 6206. A petition from August 12, 2019 on behalf of the appellant for disqualification of a judge. Paragraph 1 of Mrs. Hayat, the President of the Israeli Supreme Court, on August 1, 2019 there was a discussion. There was a decision that the appellant would submit requests to disqualify judges. Paragraph 2 of Mrs. Hayat, the President of the Israeli Supreme Court. And, BPBW 50, she wrote regard one more member in the tribunal, Justice Mazuz. Then she refuses to disqualify herself. Paragraph 3. 19.1. A question. Who applicated the petition above? An answer, Mr. Shucker, the appellant, here and there. 2. A question, in which case and matter? An answer, 8949-17 Shucker versus in specs. 3. A question, who translated it? An answer, an Israeli notary via apostille. 4. A question, did the President wrote that Mr. Shucker had claims against her ruling 1437/14 in case March 18, 4062? An answer, yes, she did. 7-206. 5. A question, did she said by herself that the claim is still pending, meaning in open parallel to case 8949-17? An answer, yes, she did. 6. A question, did she refuse to recuse or disqualify herself? An answer, yes, she did. 7. A question, does she has any type of interest? An answer, yes, she does. 8. A question, does it contradicts the maxima that a judge cannot sit on his own case? An answer, yes, it does. 9. A question, does it contradicts the Human Rights Laws Act 1988, is heard by an independent and impartial decision-maker? An answer, yes, it does. 10. A question, does the District Court before Wales has the jurisdiction to disrespect/abort case 8949-17 and get into the shoes of it? An answer, yes, he does. 11. A question, did the appellant claimed on the skeleton argument before Wales that 8949-17 is illegal and His Honour Wales should get into the shoes of 8949-17? An answer, yes, he did. 12. A question, was this quote said before His Honour Wales in the transcript and skeleton argument, Dimes vs. Grand Junction Canal 1852? No one can suppose that Lord Cottenham could be, in the remotest degree, influenced by the interest he had in this concern, but, my lords, it is of the last importance that the maxim that no man is to be a judge in his own cause should be held sacred. And that is not to be confined to a cause in which he is a party, but applies to a cause in which he has an interest. Since I have had the honor to be Chief Justice of the Court of Queen's Bench, we have again and again set aside proceedings in inferior tribunals because an individual, who had an interest in a cause, took a part in the decision. and it will have a most salutary influence on these tribunals when it is known that this High Court of last resort, in a case in which the Lord Chancellor of England had an interest, considered that his decree was on that account a decree not according to law, and was set aside. This will be a lesson to all inferior tribunals. To take care not only that in their decrees they are not influenced by their personal interest, but to avoid the appearance of laboring under such an influence. An answer, yes, it was. 8206. 13. A question. Is according to the Convention the Israeli Supreme Court the last resort and UK courts must respect the Convention 1971 said above, according to law? An answer, yes, it is. Interim summary grounds for Part C. 14. According to UK laws, the appellant proved that Wales must get into the shoes of 8949/17 January 2021 because 8949/17 January 2021 is not legal and contradicts human rights and UK laws. Grounds for Part C, Extension 1. 15. The President of the Supreme Court, Mrs. Hayat, mentioned two case numbers in her decision not to disqualify herself, in paragraph 2. 1437-14 and March 18, 4062. The appellant mentioned these two cases in the transcript and in the skeleton argument. Attached is a notarized translation of file 4062-03-18 BPBW 31-34. Before His Honor Zaccaroli, it is Appendix 9. Zaccaroli 147-149. 9206. 10206. 11206. 16. In paragraph 2, it is clearly that the lawsuit is against Judge Mazuz and Mrs. Hayat, both judges in case 8949/17. To mention, according to Mrs. Hayat herself, the claim was still pending to case 8949/17. Mrs. Hayat also mentioned that the appellant Mr. Shucker asked to disqualify Judge Mazuz as well. Since a judgment was given in 8949/17 January 2021, Mazuz did not disqualify himself. There is no need to extend any additional matter because it is describing in Appendix 7 BPBW 61-183. Zaccaroli 131-143 of the second hearing the protocol before Hayat, Mazuz, Wilner. 17. Case 1437-14 was in a matter of the defendant in specs see second page bottom left in the corner. The evidence was translated by a notary and supported by an apostille. BPBW 53-60. Before His Honor Zaccaroli, it is Appendix 10. Zaccaroli 150-152. 12206. 18. The appellant will prove through documents translated by a notary supported by an apostille. That claim March 18, 4062 was rolled up to the Supreme Court, and the judge who closed the claim is President Esther Hayat herself. 13206. Case 1227-20 Chief Justice Hayat. 1227-20 was an appeal on January 19, 4318 that was an appeal on 4062. 03-18. The meaning that the President of the Israeli Supreme Court was sitting on her own case in a matter of Shucker versus Inspecs. 19. The appellant will prove through documents translated by a notary supported by an apostille that the President Mrs. Hayat refused to recuse herself of case 1227-20. Before His Honor Zaccaroli it. 14206. Is Appendix 11. BPBW 40-43. 15206. 16206. 17206. 20. To remind you case 1437-14 was Shucker versus Inspecs. 4522-14 was also of Shucker versus Inspecs. Mazuz was a member of the tribunal on case 8949-17 and 4522-14. See proof by a notary and apostille. Before His Honor Zaccaroli, it is Appendix 11. BPBW 58 to 59. Zaccaroli 153 to 156. 21. 22. It has been proved that both Hayat and Mazuz had interest and sat on their own cases. Two members of the Tribunal of 8949-17 were partial in a matter that contradicts human rights, is heard by an independent and impartial decision-maker. And the maxima. Nemo debet esse iudex in propria sua causa. Dimes v. Grand Junction Canal 1852, UK. Grounds for Part C, Extension 2. 18206. This part is for the one that really seeks to deepen. 1437-14 was Schucker v. in Specs. It was an interim appeal on Case 23008-05-12 Schucker v. in Specs. 37300-07-12 is the continues of 23008-05-12 of Judge Hayat before being the President. 4522-14 was a final appeal on 23008-05-12 and 1437-14. In Tribunal 4522-14, Judge Mazuz sat on an interim appeal of Judge Hayat's decision 1437-14. In Case 1227-20 imitates Hayat, a lawsuit against herself and against Judges Mazuz, Case March 18, 4062. Finally, these two judges, each of whom is aware of the transgressions and biases of his friend, joined together in the same tribunal to order against the person who exposes all the biases. When the cases are arranged in this way, 8949-17 appeal on 37300-07-15. 37300-07-15 continuation of 23008-05-12. 1437-14 is an interim appeal in 23008-05-12. 4522-14 was an appeal against 1437-14 and on 23008-05012. This means that President Esther Hayat is sitting in Procedure 8949-17 on one of her appeal decisions. Decision 1437-14 in the matter if the defendant has or not an affidavit. All are in a matter of Schucker versus. In Specs. Grounds for Part B. 23. The appellant presents 2 pages in Hebrew and English. These pages are from the Hebrew affidavit of Mr. Paul Lovett, the defendant's witness, before Judge Renner in Israel Case 37300-07-15. Before His Honor Zaccaroli, it is Appendix 12. BPBW 192 to 206. Zaccaroli 157 to 171. First page and last page. The question arises, is this document an affidavit or not? And the answer is no, because it is not. The first word on the first page in the title is, meaning affidavit. At the end of the affidavit there is no third party to warn or identify the witness. The conclusion that this is the Hebrew document is not an affidavit but just a paper with text. The appellant will present the English version. Before His Honor Zaccaroli, it is Appendix 13. BPBW 108 to 124. Zaccaroli 172 to 188. Of the Hebrew document, only the first and last page. The last page has signatures, and it looks like an affidavit because a third party, a legal authority, approved the signature of the witness, and we can see the witness signature also. First page Hebrew. 19206. First page English. Last page Hebrew. Last page English. 2206. 24. These two documents given to Judge Shirley Renner on Case 37300-07-15. 894917 was an appeal on 37300-07-15. Initially, the affidavit was given in English. Since an affidavit in English is illegal in Israel, the defendant translated it into Hebrew later. It is unknown who translated the document, not even a private third party. It is known for certain that there is no reference of a translation of a specialist company. It is known that a notary did not do this. The conclusion that the Hebrew translation is not an affidavit but a translation. 25. Why it is so important. Because one of the accusations in case 1437/14, Justice Hyatt in the matter of Shucker versus Inspects mentioned case 1437/14 on 894917 petition to recuse herself. Shucker versus the State of Israel is the Mrs. Hyatt the President ordered the defendant has an affidavit. Consider it that in Israel, Hebrew is official language and English is not legal. This is the interest why she sat on her own case to cover her own failures. Even if it is not the case, March 18, 4062 was still pending in parallel to 894917. 26. The appellant, a native Hebrew speaker at the highest level, poetry, literature, was a Jewish religious orthodox. In the past he knew the Bible orally, almost all. He controls the grammar and syntax as a specialist. The appellant gave an oath before hearing that the translations contradict themselves and the defendant forged the document. Before His Honor Zaccaroli, it is Appendix 14. BPBW 260-262. Zaccaroli 189-191. 21-206. 27. On hearing the appellant compared the texts, he was reading the Hebrew version and the English version. These pages are the main fault of Renner's. His Honor Zaccaroli cannot speak or understand Hebrew as His Honor Wales does not also. Who can judge if the Hebrew and the English contradicts each other? On hearing nobody could. Only the appellant was speaking Hebrew, Wales did not, and the defendant did not also. How can a judge order that the appellant is not right? The appellant speaks two languages, English and Hebrew, all the other only English. This is insane. The documents Hebrew and English appendices 12 and 13 were given by the defendant, not by the appellant, both before Renner and Wales. Every document the appellant brought was translated via notary. Part B. Why the Hebrew affidavit is so important. 28. To prove that the defendant is not reliable, the defendant forged court's documents. It is criminal. It is perjury. 29. The Hebrew affidavit contradicts itself. Renner quoted part of it that the defendant admitted there was an agreement, and after Renner quoted some part of it saying there was never an agreement. Before His Honor Zaccaroli, it is Appendix 16. BPBW 158-167. Zaccaroli 193-202. The quote, "We are happy for you," is an appendix of the Hebrew Appendix 12 before His Honor Zaccaroli BPBZACROLI 157-171. It is not possible to find now and no need. Nobody argues about the legitimation of the quote. And the continues of this paragraph. 22-206. 30. It is possible to prove it only if court will order a translator or a notary, otherwise the person speaking both languages is a specialist witness, and it is the appellant. The defendant gave these documents, and the appellant is a Hebrew mother tongue speaker. He reads Hebrew perfectly. 31. The appellant claimed under an oath that they contradict each other in the transcript and hearing. Before His Honor Zaccaroli, it is Appendix 14. BPBW 260-262. Zaccaroli 189-191. Part B. A brilliant way to know if the Hebrew document is fake or not without a notary and without translating it at all. 32. the defendant gave Judge Wales a translation from Hebrew to English of Judge Renner's ruling in Case 37300-07-15. The judgment was translated by a private Israeli company, paid by the defendant, and not by a notary. According to the defendant won and there is no flaw in the verdict of Renner, a doctor of law studies. Surely, according to the defendant, the English and the Hebrew are the same and according to the appellant they are not. The appellant quotes from the judgment from the same paragraph number 22. 33. The appellant will provide the appendix that Renner rely on its affidavit paragraph 43 but, instead of Hebrew affidavit the appellant will rely on the English version. 23-206. Summary grounds for Part B. 34. The claimant proved that Renner's contradicts herself. Even with no need to read Hebrew but to rely only the documents that were given by the defendant, we can see that the defendant was happy for the claimant to market cat safety glasses, as eyewear glasses is the same description, but not for optical glasses. Was, 2 times happy is not would be happy. Further, there was never a Hebrew affidavit before Renner, although she said there was. Part B. The solution for Part B. 35. The solution is that court should order that all the Hebrew documents and not only the Hebrew affidavit given by the defendant before Wales should be translated via a notary and not via a private company. A summary of all documents should be translated. Justice Renner's Order Appendix 16 Zacharoli 193-202. Justice Reuven Shemia's RSP order that is not given here since it is too many pages less relevant to this notice, and the Hebrew Affidavit Appendix 12 Zacharoli 157-171. Otherwise, it is Babylon Tower. Notaries' translations are solid rock evidence. His Honor Wales refused to do so. Before His Honor Zacharoli it is Appendix 15. BPBW 215. Zacharoli 192. 36. 24-206. Part A. His Honor Woodburn ordered for an interpreter. Nobody showed. 37. Woodburn's order, second page on the bottom. Before His Honor Zacharoli it is Appendix 17. BPBW 211. Zacharoli 203-206. 38. His Honor Wales bias the trial. 39. Regard the transcript. A judge who states that no decision has been made to request an interpreter, even though the decision was read to him, and he still claims that it is not a decision, then the judge is not qualified to sit on the hearing. The order is the court will request an interpreter for the claimant. Is well known that judges in UK gives instructions to clerks in court. 40. A judge who allows the defendant to translate orders of a foreign court without a notary, he is not qualified to sit on the hearing. 41. A judge that orders without a translator or a notary to translate him the problematic text in a foreign language that he does not speak or understand is not qualified to sit on the hearing. 42. A judge that makes a show that he can see 2 very long texts in Hebrew and acknowledge that they are the same within 3 seconds is not qualified to sit on the hearing. Wales is not a scanning software. It is not possible to do it within 3 seconds. 43. Did His Honor Zacharoli understood the Hebrew texts? No. For a non-Hebrew speaker it is the same as Chinese. 44. The interpreter was for His Honor Wales, to try a fair trial for the claimant. He did not listen to the plaintiff according to the well-known saying Audi Ultram pattern that he could not listen to a language that he does not understand. Therefore, Judge Wales violated human rights. 45. Unfortunately, before His Honor Wales it was not a hearing but a show fake law. About the £31,000. 46. The fine £31,000 is a disgrace, same as piercing a man with a Dula spear. The sum is highly high. Final summary for Part A, B, C. 47. These are the questions asked in the summaries before Honorable Judge Wales, hearing date August 2, 2022, skeleton arguments on behalf of the claimant representing himself. The main question in this hearing is, if the 25-206 claimant will prove that Appeal 894917B.P15 of the Israeli Supreme Court, in the matter of the claimant and the defendant, a UK company, was in contradiction to Human Rights Act 1988 Law Article 6, a fair trial. If then, is this court has jurisdiction to get into the shoes of 894917B.P15, other words, if the claimant will prove that Hayat, the president of the Israeli Supreme Court, and Mazuz, ex-attorney and a justice in Israeli Supreme Court, were sitting in their own cases. 894917B.P15 and 1227/20B.P41 in the matter of the claimant and the defendant. The second is if the defendant's witness, Mr. Lovett, gave a testimony, is it a perjury and miscarriage of justice in Israeli courts supreme and district? If then, is 894917B.P15 and 37300-07-15 are unfair trials or not? End of quote. 48. The claimant and appellant prove that His Honor Wales was wrong. His Honor Wales become the lawyer of the defendant and bias the trial. In his refusal to give permission for an appeal and refusing to translate the documents via a notary, he became the accountant of the defendant. His Honor Wales violated several human rights and distorted justice. 49. The defendant forged documents along 3 years and more, misled District and Supreme Court in Israel, submitted perjury, supporting violating basic human rights. The claimant asks court to order a fine to the benefit of the claimant. The defendant actions are criminal, no other than UK companies paying bribery in Africa. How to try the next step. 50. See skeleton argument before Wales, page 18, paragraph 18. 18. A better offer how to manage the trial. 1. No need to summon any witnesses. The defendant's lawyers investigated the claimant himself and others in 37300-07-15. The claimant investigated Mr. Lovett on 37300-07-15. The defendant investigated the claimant 2 investigations, one as a key witness, the second as an international commerce expert. 2. The claimant declares here a new declaration and swear under an oath before His Honor Wales. The defendant, and not the claimant, gave to 894917 the said above investigations as appendices plus ruling case 45-2214. The claimant has it in his hand, not a copy but an original with a Supreme Court stamp. The defendant should back up these documents under apostille. 26-206. Translation to English, 1/45/2214. Date, July 26, 2015. Renner mentioned 45-2214 on the last page of 37300-07-15. 2. Renner's ruling 37300-07-15 date October 18, 2017. 19.3. 37300-07-15 date December 5, 2016 Protocol. A hearing. By the way, on this hearing, that I hold now in my hand, it was written that Renaer admitted her husband lawyer Mr. Zvili represented the state is case 23008-05-12. Renner's is the bachelor name and Zvili is her husband's surname. She told no one, the claimant discovered it. In this hearing also, she ruled that 37300-07-15 is a natural continuous of 23008-05-12 meaning as one unit. 4. 37300-07-15 date April 4, 2017 Protocol. The defendant investigating witnesses and investigating Mr. Shucker. 5. 37300-07-15 date April 24, 2017, Mr. Shucker investigating the defendant's witness, Mr. Lovett. 6. Regards the English/Hebrew affidavit, the notary. should translate only the contradictions between them, since it is not a good advice to have another translation for the original. He will find the contradiction between 42 and 43 as said above. Maybe there are more. 7. The claimant is asking to add a ruling of the Israeli Justice, Solberg, Case 525017 Shucker vs. in specs. By the way, if talking, the claimant has maybe 30 trials regarding specs and the justice is in Israel and never won even one. Always lost. It is clear why. The claimant will expose how the Israeli Supreme Court cheat. He quotes the law, after contradicts the law. If you complain you will pay a fine. 3. Every party will be able to use any document that already approved to be in this case, POC notary appendices, CEO testimony, etc. A fair hearing will be that both parties will have a bundle under an adversary court. The defendant will serve the bundle and translate all documents and pay the notary. Each party will be able to have skeleton arguments based on the above documents. Any other idea is non-efficient. End of quote. The appellant Mr. Shucker.
Thank you for watching.